remedies available to you.
All right, let's talk about when somebody loses their job. This is really the crux of our discussion tonight, I think, unless we go other places. But when somebody is fired, all right, how does that, what are the person's rights?
Well, as we discussed, it's difficult in New Jersey because at will means that an employer can terminate you for any legitimate reason at any time, as long as they don't breach your rights. So in this economy especially, if it's a mass, what we call RIF, a reduction of force, very difficult to show that there's any malicious intent by the employer. However, if you're fired and it's a sole firing or very limited firing, you need to review how that happened, how you came to that point. You need to review the facts, because a lot of people don't realize that they have a claim for wrongful discharge until many weeks or months later after the Termination Act itself. So you need to put together the puzzle to see exactly whether any incidents that happened leading up to the termination.
Now, what about the employment contracts? A lot of people get a job, maybe there's a letter written, maybe there's a contract, maybe there's a restrictive covenant of some kind, a non-compete clause, and then there's some internal policies. Now, what are the things that you look for when somebody comes to you and says, I was just fired, I was making a lot of money, and, you know, what do I do? How do you handle that?
Mark, we make our living trying to overcome the at-will concept that Bill indicated. In your question, if you have a contract, you could remind me of Joe Namath, former New York Jets quarterback, with a 3-year no-cut contract at $500,000. He gets cut or injured on day one. Because he had a written agreement, he gets paid. The majority of our clients don't have an agreement. So in New Jersey, the law cuts toward us in many, many ways, because when someone comes into our office and said, Bill, I just got terminated, but my boss said you can't do anything to me because we're at will, that is nonsense. In New Jersey, every day that goes by, the at-will concept is chipping away and being eroded more and more. New York is a little bit more stringent and more difficult. But if you have a contract that gives you certain guarantees, that's a wonderful thing. Employers still have a tendency, Mark, not to back that up at times. When you have a restrictive covenant, you can't compete. Bill Jr., I know, has litigated restrictive covenants probably 3 or 4 times in the last 2 years. And when your employer makes you sign a non-compete saying, you're not going to compete in our business for 2 years, you're not going to compete anywhere, that's nonsense. He has, through Judge McKenzie, eroded that particular restrictive covenant to 6 months to 12 months and made actually restrictive covenants obsolete in many, many ways.
Bill Jr., what's the logic behind, how did you break the restrictive covenant?
I've been on both sides of restrictive covenants. I mean, at its essence, a restrictive covenant, what it really should be used for is to protect the secret sauce at a business. So no one can come in, steal your secret sauce, take your clients, and go set up their own little company right across the street from you and put you out of business. That's really an important concept, and I understand the interests that are involved in that. But I've been on the other side, where I feel more importantly is someone's ability to make a living. And that trumps any and all rights out there, the courts have said, because when you have someone sign a non-compete agreement, and we had a case where we had a lower-level individual, wasn't a high-ranking executive, and on the first day, when you go in and you sign all your forms, he happened to sign a form that he didn't even read, didn't have a chance to have an attorney concept, and it was a restrictive covenant non-compete. And he came to us when he left the company to go find another job for a small raise, a couple $1,000 more. He realized that he signed this because they served this new company with an injunction. I had to go to court. He retained us to go to court and fight it. And to make a long story short, we argued successfully that this is somebody who was a lower-level employee or mid-level employee. He would honor the portions of the restrictive covenant that were, in essence, protecting the secret sauce and the non-solicit of their own workers and customers, but let him go make a living. And that's really what it's all about.
Is there any difference between somebody who leaves a job or who's fired from a job when you have a restrictive covenant?
That's a good question, and I've had both scenarios, and I do have to say that if someone's fired, you have more leverage with the court to say this wasn't even this person's own doing. They were
Right.
essentially forced to leave, and as such, if the employer is terminating you, you should have the right to be able to go wherever you want. If you leave on your own, not to say that you can't defeat a restrictive covenant, but it does make it a little more difficult because then the court looks at your motives.
All right, so if somebody comes to your office and says, I was let go of this large corporation, high-paying job, what can you do for me? What are you have a checklist or something that you look for to help that person. Let's go through that checklist if you can.
Mark, the checklist is ingrained in our minds. We do this every hour of every day, and when a person says, I've been terminated, the new theory is, this is a tough economic time, we can't use you anymore, therefore we have to let you go, and the tears come down their faces, meaning the employers. The first thing we look at is the reason conveyed to the terminated worker the real reason. And Mark, in an hour and a half initial consultation, 95% of the time, the reason conveyed is not the real reason. These are the things, and 95% of our cases, we can settle without even going to court and filing a complaint. We go all over the country. I've had cases in New Mexico, San Francisco. We never go to court. So the bottom line is, we can do one of two things primarily. Try to get the individual their job back. That's tough.
Right.
Negotiate a fair and reasonable severance package, permitting the person, male or female, to walk away with their head held high. And Mark, we've learned it is a rare day in this 2009 era to be able to walk away with your head held high and just believe what your employer says, because there's no more commitment than loyalty at work.
All right. Let's take it to the next level, or beneath the skin, so to speak. The employer has some other reason for firing you. All right. What are those other reasons, and why does that give you any leverage to cut a deal to get them severance pay?
Well,
or their job back, for that matter?
it's called pretext, and essentially it depends on what the other reasons are. If the other reasons are legitimate, then they have nothing to worry about. But a lot of times, the reasons aren't legitimate. For instance, we had a trial that we actually had to go through where we represented a woman who was terminated, and given a reason for her termination was because of cost cutting and performance reasons. That was what she was told. After we went through discovery, it was made clear that the powers that be in the company did not prefer to have a woman in the high position that she is in.
Civil rights.
Civil rights
Correct.
comes back to protected class. And what happened was a new regime comes in and realizes that they don't want her. They'd prefer to have a male in that scenario. So they come up and manufacture a pretextual reason, which was performance, cost cutting, and say that's why you're fired. But through discovery, pretext is essentially like a styrofoam cup, and you don't have to, not a lot of people get the smoking gun per se. In this particular case, we got a smoking gun, I think, but usually you just poke holes in that, and if you just find enough to poke enough holes for the liquid to go through the cup, that's when you can show pretext. In this particular case, it was interesting because after we did our investigation, we found they hired somebody a week after they fired her in a very similar position. How are you cutting costs if you're hiring somebody for the same position for the similar money? Of course, a male in that scenario. Second thing that was interesting was after we did a little digging around, we found advertisements for jobs. In this day and age, it's unbelievable, male candidate preferred in the actual ad and in the internet for the position. Now,
That firm didn't have a good labor, employment attorney.
they did not have
advising them,
us.
right?
That's
Generic position. Technical writer, males preferred.
And their reasoning for it in court was that, well, they're dealing with people overseas, and in this particular instance, but they wound up losing. The jury didn't buy it. But the thing which is, things like this are still going on. People come to me and ask me, well, you know, no one in this day and age would do something like that. It happens.
It happens.
Sexual harassment happens. Inappropriate hostilities happen. It's still going on.
Yeah, we're going to talk about the sexual harassment and workplace a little bit later. So the person comes to you who's been fired. You get retained. You then communicate